Thank you very much, JP. Good evening, Judge Matojane.
Good evening, Chief Justice, and good evening,
Are you well?
commissioners. I'm ready to go to Chief Justice.
All right. Okay, please accept our apologies for keeping you waiting this long, sir.
Yes, the apologies accepted, Chief Justice.
Thank you. For how many years have you been a High Court judge?
I've been the High Court judge for the past 11 years. I've been an attorney for 18 years, and I've acted at the Western Cape High Court for 2.5 years. All in all, I have 31 years in the business of the law.
And for how long did you act at the Constitutional Court?
I acted at the Constitutional Court for 1.5 years, I think 6 terms.
What about the Supreme Court of Appeal?
Sorry, correction. I was at the Supreme Court of Appeal for 1.5 years.
And the Constitutional Court?
Or at the Constitutional Court, I acted there for a term.
And very briefly, just give us the highlights of how all this experience has prepared you for the SCA.
Chief Justice, I thought I should talk about the traditional route to a position of a judge in South Africa. You have to be, it's good education, good university, a practice that attracts lucrative commercial work. Then you acquire technical skills that qualifies you for appointment as a judge. If you are a white person in the old South Africa, you only had to be a prosecutor, a magistrate, attorney or advocate, attract lucrative instructions, which gives you the technical skills, and then you qualify to be appointed a judge. If you are a black, I'm going to talk about my lived experience. I was born and brought up in Soweto. I remember at matric, we didn't have a maths and science teacher, but I managed to secure a merit bursary to study mining engineering at Wits. I was admitted. The day before orientation, I remember, I was told that I need to phone a certain Gerrit Viljoen, who was the Minister of Bantu Education, to find out whether my application to study at the white university has been accepted. It was refused. At that time, applications to universities were closed, and I heard that the University of Zululand accepts walk-in applicants. That's how I ended up at the University of Zululand, where I did my BProc. I got a bursary that was administered by the university. I ended up doing LLB at the University of Zululand because at the time, my parents, who didn't have any formal educations, didn't have the means. I came to Johannesburg with my LLB degree from the University of Zululand, looking for articles. Big law firms, if you're a black from a so-called Bush University, would laugh at you. It wasn't easy to get articles. The Black Lawyers Association had placement schemes in terms whereof they raised funds overseas and paid stipend to black lawyers to take up article clerks. That's how I secured articles in a one-man practice. We couldn't attract lucrative commercial work. We could only do criminal cases. There was state of emergency. People were being arrested randomly. We did a lot of criminal defense work, public violence cases, and because, I mean, we're acting for poor people.
Yeah. May I try to help you, Judge?
Yes, sir.
Please, I'm sorry to interrupt you. I'm very sorry.
Okay.
I was just thinking that because you are now applying for a position at the Supreme Court of Appeal, you may wish to focus more on aspects of your experience.
Yes.
That would demonstrate to us how equipped you are for an SCA appointment. Just the highlights. Some of the details will come out as commissioners put questions to you. I'm really sorry to do this to you. I thought I'm just trying to help you focus better.
I understand. The point I wanted to make was this, that the fact that we're denied opportunities should not be the reasons why we should not be considered for appointment in senior positions. Chief Justice, I believe that constant improvement is better than a delayed perfection. I registered for a master's degree at the University of Joburg. Then it was called Rand Afrikaanse University. I then registered for another master's degree in commercial work with the hope that one could develop one's base of an experience and concentrate on commercial litigation, arbitrations, and insolvencies. I have to bring this up, Chief Justice. Our Judge President Malamba has initiated a pilot commercial court project. I'm the convener of that pilot project. We seek to attract commercial work to the High Court. The project is doing well, but I must say that of all the cases that I'm case managing, about 16, I'm yet to see a black counsel instructed by this big commercial firm to appear for them. I'm yet to see a black law firm. 20 years down the line, we will be saying, black people don't know commercial law. Black people cannot do arbitrations, insolvency practice, mergers and acquisition. It's a concern that I thought I should raise, that we, black lawyers, despite the stumbling blocks that are placed in our path, we are ready. We want to be given a chance. We want to advance. We want these big commercial litigants to instruct black people. It's going to take time. My concern, as I said earlier, is this, that 20 years down the line, we'll be still be singing the same song.
Thank you, sir.
Back to your question, Chief Justice. I think I have acquired the necessary for rank 6 skill after 31 years in the legal profession.
Thank you very much, Judge. President Maya, I'm going to ask a favor of you before I hand over to you. As the names are being mentioned, because sometimes I step aside when I have to, please just write them down as well so that you and I have a common list of who's going to put questions. And even if I'm not there, you're able to proceed with the meeting. Thank you. Colleagues, may I have your names, please?
Muimang.
Who?
Muimang.
Oh.
Matojane. Nyambi.
Is that all?
Barnard.
The commissioners are tired, CJ.
Yeah, no, we understand. We still have a long way to go. I mean, we still have 3 more candidates after Judge Matojane. Over to you, President. Is there another colleague?
No, I just wanted to record that we're not tired. We only have we do not have issues to raise with the candidate.
That's good to hear.
What is before us is very clear. Maybe there will be follow-up questions. Thanks.
All right. President, over to you.
Dodovo is spreading a rumor, CJ.
Is spreading a rumor?
Yes.
All right. Okay.
May I go
No,
ahead?
that's over to you, President. Over to you.
Thank you. Good evening, Judge Matojane.
Good evening, President Mai.
You come from a division which piloted court modernization and systems such as case lines, and I have to say that you've shown yourself to be quite adept at the new technologies. And the SA is a newcomer to these innovations, and you had a big hand in helping demystify, allay our fears and persuade us to actually join the bandwagon, because most of us down in Bloemfontein are quite old, and technology is a big hoja.
Thanks.
So I just wanted to commend you for that and the role you played in guiding us towards the right direction. Can you just briefly explain the benefits case lines, for example, means, especially in this new normal of running courts on the virtual platform?
Thanks, President Maya. This is another initiative by Judge President Malambo, where he went out of his way to have all files digitized. And we ran a paperless court at the High Court in Johannesburg. And this came at the right time during the era of COVID-19, where we are able to conduct trials from our respective homes. Well, there are technical problems in that we didn't have the tools of trade, but through his relentless effort, most of us have now been provided with updated and up-to-date computers, which makes it easy for us to conduct courts visually. The system is cost-effective. We no longer have problems with files getting lost or misfiled. We no longer have physical files being moved from one point to another. Everything is done electronically. Recently, I was doing a lift to appeal. One of the counsel was in New Zealand, the other one in Cape Town, and I was here in Johannesburg. The system is working. It's working well, and it saves litigants expense, and I think it makes courts accessible to poor people. In Johannesburg, we have dedicated courts that have the necessary equipment to enable those who can't afford or who don't have the means to access the court, to come to court, and the court staff assist them in joining the proceedings from the court building.
Have you had a chance to write judgments at the SCA, and if so, how many?
I have written judgment at the SCA. Unfortunately, I do not.
You don't have the exact number?
I don't have the exact number, but I have.
But it's quite a few, huh?
It's quite a few, because we write 1 or 2 judgments per term at the SCA.
Mm. You recently co-wrote a judgment with Justice Bonan in a citizenship matter. It's the case of Minister of Home Affairs against Joseph. Now, co-writing judgments is not a common phenomenon, not just at the SA, but in all courts. May I ask how that came about and how you found that experience?
I don't know, but the matter was allocated to both of us. We worked together. We discussed the matter. We divided into two. He wrote one portion, I wrote the other portion. And then we subsequently met and then finalized the judgment together.
And that there was no problem there. You were able to work seamlessly together.
Yes, there was no problem. In fact, Judge Ponan was, he was helpful and willing to share his long experience at the SCA.
Everyone who has worked with you at the SCA has commended you for your work ethic. You are known as being a hard worker, which is why I am uncomfortable asking you this question. It's something we discussed previously, and it concerns a report that was made to me by a senior colleague who says he allocated you judgment writing responsibilities in a land restitution matter that was in the fourth term of 2020. And he says he was quite disappointed with the draft judgment that came out. It was certainly not what he expected, especially from you. And it ended up needing a lot of rehabilitation. And then he says, more disappointing now was that on the day of the case conference, you appeared unsure. You actually had a series of drafts that had been exchanged as is usual. You know, people will make their comments and you incorporate and you recirculate. But now you actually had the wrong draft, which is unforgivable for a scribe because it's your judgment. You are the one who should, make sure that your colleagues actually have the right document in front of them. So you appeared unready, and then after the conference, you recirculated something which had material that had not been discussed by the collective in the conference now, but then happily, ultimately, it was all sorted out. What happened there? Is it lockdown fatigue? Or what happened to you?
I should start extending my apology to the senior judge concerned. This is a case of misunderstanding or miscommunication. I wrote a judgment, circulated it, and there was delay in having colleagues commenting on my judgment. I remember I had to send a reminder to them to say, it's now over 3 weeks and I haven't had anything from yourselves. So it was a panel of 5 judges. Then I received all the 4 comments. Now, I work from home. You have a laptop screen. I also have a monitor on the side. So as I was incorporating these suggestions, I was doing it online. I should have maybe, it's just that I don't have a printer at home. I should have printed all these judgments because they had tracked the changes. Maybe I should have, on hindsight, I should have printed all these judgments and went through their individual comments. So what happened was I was working on my original draft and tried to incorporate their comments and suggestions. The senior judge had suggested what I did in there's this paragraph in the Plascon event case that deals with dispute of fact in motion proceedings. I cut and pasted the whole paragraph in the judgment. The feeling was, as an appellate court, we can't just quote a judgment in verbatim. We should put it in our own words. So what I did was, the senior judge formulated, summarized that paragraph. And in the process of preparing the second draft, for some strange reason, I lost his tracked comments. And knowing that the concern was that we should use our own words and formulate, we should formulate our own words, I thought that I could do it myself. So I tried to summarize that plus one even principles. I circulated it, but before doing that, I found a second senior colleague for directions. I said to her, look, I'm battling to find this email that contains the formulation by the senior judge. And I asked the senior colleague if she could forward to me the email that came from the presiding judge. She advised me that to approach the senior judge directly. I did that, and he agreed to resend the formulation of the Plascon Evans rule. I incorporated that in my judgment, and I circulated the third draft. That's what I'm saying. It was a misunderstanding. It is regretted. I've never had problems in writing judgments, and I've never delayed in delivering my judgments. And I can confidently say that I have no problem with writing judgments.
Yeah. Thank you for that explanation. And I must just make clear that this senior judge was also, crestfallen, and he said he needed this to be raised with you because, we want, the court is under so much pressure right now, as you would have experienced with all the work and most of the senior judges leaving. So we are just spread too thinly. So people should, just take care of their business and not rely on others to look out for things that they, should be responsible for. Otherwise, we know your work. As I said, we know your work ethic, and you have proved yourself at the court and elsewhere. But thanks for the explanation.
Thanks.
That will be all, Chief Justice. Thank you, Judge Matojane.
Thanks, President.
Thank you, President. Honorable Moima.
Thank you, Chief Justice. Good evening, Judge Matojane. This side.
Yes, thanks.
The question that I want to pose to you is linked to the work and the role that you played with regard to influencing the position of the new boss in charge of the Hawks. I noticed that in the matter that involved the Helen Suzman and Ntemeza, the Supreme Court of Appeal set aside the appointment of the Hawks boss in Ntemeza because the court said that the former minister Nhleko, in his appointment of Mr. Ntemeza, acted in bad faith because he did not take into account your judgment in the matter between Sibia and the Minister of Police. It's a matter around, I think, 2013.
Yes,
that involved the rendition.
I know about the matter.
Yeah. Can you just give us a reflection in terms of your observation in terms of given that angle and how extensively you were quoted, the court can play a role in whipping us as lawmakers and political office bearers into line when somehow in a manner in which we work on a daily basis, we disregard the rule of law, good governance, which involves the need to ensure that at all times we act rationally. We act in a manner that is accountable. We act in a manner that is transparent to ensure that the decision that we take must be informed by the sound reasons. Thank you, Chief Justice.
I think in anticipation of other questions, I should say this, that as judges, we take an oath to be faithful to the Republic of South Africa, to uphold and protect the Constitution and the human rights entrenched in it, to administer justice to all persons alike without fear, favor, prejudice, in accordance with the Constitution and the law. Our judgments are based on the facts and the legal arguments that are presented before us. We decide life issues. The issue is, what were the facts before me? What legal arguments were presented to me? What was my finding? I haven't reread the case, but I do know that the matter went to the SCA, and the SCA agreed with me, and some important principles were laid down in that decision. The point I'm trying to say here is the public has a right to expect that their matters would be adjudicated upon fairly, impartially, by a judge, without fear, without favor, without prejudice. And that's democracy that we all fought for. I'm sorry, I can't go into the specifics of that matter, I can't remember, but all that I can tell you is the judgment is based on the legal arguments that were presented before me. All the parties were represented. I had argument from both sides. I applied the law as I understood it. I wrote a judgment. What happened thereafter is really beyond me. I can't comment.
100% I agree with you. I think the point is that you found that the suspension and the measure of Anwar Dramat and Sidia was done in bad faith. But I think my second question relates, don't you think that sometimes by so doing, by coming up with such judgment, which obviously has an influence in terms of how the executive operates, because in this instance, the executive wanted Ntlhameza as the Hawks boss, and as a result of the decision by the court, which other people might have taken it as judicial overreach or judicial activism.
But
how do you balance that within the context of the separation of powers? Thank
my
you.
answer to you is this: those facts were not before me. I wasn't called upon to decide political issues. I had to address myself to the facts before me. Had I gone beyond those facts, my peers on appeal would have came hard on me. So as a judge, when I decide a matter, and this has to do with the independence of the judiciary, as a judge, we are called upon by the Constitution to act fearlessly and according to our conscience, because we are accountable only to the law. All those, the noise it's really relevant. I don't know. I have nothing personal against Mr. Ntlhameza. I didn't know that he was due for appointment or anything. I confined myself to the facts the legal arguments that were presented before me, and I wrote my judgment. So that judgment obviously states the reasons why I came to a particular decision. An aggrieved litigant has a right, it's not the end of the matter. He has a right to take the judgment on appeal. He has a right to criticize it, tear it apart, tell the world how ignorant of the law I am. There's nothing wrong. You have the right to demonstrate, vent your anger. It is to be expected that in any litigation, one party is going to prevail and the loser is not going to be happy. He has a right to vent his anger, but you have to draw a line. You cannot make obviously false allegations against the judge that the judge is corrupt.
Okay, let me come in, Judge Matojane. Honorable Moiman, do you still want the judge to go on, or do you have a sense that he has answered?
Yes, sufficiently canvassed the point that I was raising, Chief Justice. Thank you, Justice Matojane.
Thanks, Mr. Mena.
Thank you, Honorable Moiman. Commissioner Matolo Dlepu.
Thank you, CJ, and good evening, Judge Matojane.
Good evening, Commissioner Dlepu.
All I wanted to speak to you about your judgment in proxy smart.
Yes.
You know, and what I must actually emphasize that it really saved the profession. I know that the profession was at tenterhooks regarding this issue of proxy smart. But what I wanted to understand from you, it was a perfect judgment. It was good. Do you think your experience as a conveyancer really assisted you in coming to that conclusion?
Yes, it did a lot. Yeah, my answer is it was good that I knew what was the issues, what's likely to happen if an individual, an entity can take over convincing them and employ convincers as clerks who just go and register document.
Thank you. Thank you, CJ.
Thank you, Honorable Commissioner. Honorable Nyambi.
Evening, Judge Matojane.
Good evening, Commissioner Nyambi.
As an experienced judge of the division here in Gauteng, you went to act in the SCA. I'm taking it from the president of the SCA, where you even apologized to the senior judge about
Yes.
the particular judgment. If maybe you can share with us your experience in terms of workload, collegiality in the SCA, and your experience here in Gauteng, so that we can have a sense.
Chief Justice, in Gauteng, we are a closely knit family. We are all collegial, and I really have no issues. My experience I was warmly received at the SCA. I know I'm expected to join the bandwagon and speak ill of the SCA top 6, but I was well received. There was a reception committee. They met with us. They explained to us their protocols, the do's and the don'ts, and I never had problem in going to any senior judge to discuss an issue that was bothering me. So I must say I was well received, and my experience at the SCA was enriching. You see, in the High Court, you write, it's your judgment, you deliver it, it's out of your hand. At the SCA, they actually appeal your judgment in your presence because some of these guys have been there for many years. And in most instances, the judgment that you are writing, they've written same judgment on the same issues. So it helps to engage them and debate with them. And look, there are always office politics. If you have nothing in your hands, you have time to follow these gossips and complain. I would say that it was an enriching experience. I mean, I enjoyed interacting, exchanging ideas, and benefiting from the long experience that those guys have in the division. I have no complaint.
Oh, I wanted to ask you this one question, but
Yes.
because we have canvassed the issue of the top six, but now you are saying you don't want to join the band work on and speak ill about the top six. Why are you saying that?
Maybe I should have said I've heard a lot about the top six. Even when I was invited to go to the SCA, I was warned to expect to be ill-treated, undermined, belittled, and all that. And I suppose maybe because of my years in the practice, I've developed a thick skin. So I don't think ill treatment by any judge would have had any effect on me or deterred me. I fight my battles. I wouldn't be, I don't think I would have been intimidated or allow a senior judge to undermine me.
Thank you, Judge. Thank you, CJ.
CJ, can I follow up?
Yes, please.
Judge,
Yes, Mr. Mandam.
there is a genuine concern by your colleagues that they are looked down at, that senior judges are condescending on them. And even the leadership of the court confirms that. And then you come here and say you have no time for gossip then, when there is a legitimate concern of so many respected colleagues of yours. And when you come and say it's a gossip, you're dismissing it like it's not worth of our attention, because you'll agree with me that if there is such an attitude by senior judges on other junior judges, whereas female judges, it must be a concern to you and to all of us, and it
Yes.
cannot be dismissed as a gossip.
Yes, Mr. Madama, maybe I should withdraw the word gossip. I should have said I don't have that personal experience. So, yes, there are talks that people have been ill-treated. I can't deny that, but it's not my personal experience.
Thank you.
Thanks.
Commissioner Barnett?
Thank you, CJ. Judge, very quickly, in the Fly Africa matter, you dealt with contractual damages, the SAFA versus Fly Africa.
Yes.
And in that matter, you made a finding, dismissed the claim. It was overturned by a full bench. And then in the SCA, again by a bench of 5 judges, overturned. Where do you think the full bench went wrong in that matter?
I didn't get it. The SCA confirmed my judgment. What happened was the full court set aside my judgment, the matter went on appeal, and the SCA agreed with me.
Thank you. I think the question was, where do you think the full bench went wrong?
I haven't read the contract, the case recently, but it was a contractual dispute. It involved an interpretation of a contract. Law, it's not an exact science. 2 plus 2 will always be 4. But when we come to interpretations, one cannot say that this is the only and correct interpretation of a contractual clause. That's why in appeals to the full court, you'd have 3 judges. As at the SCA, you'll have 5 judges. At the Concord, you'll have 11. and you have dissenting judgment. I think it was a contractual dispute. I interpreted the contract correctly. The SCA, the full court disagreed with my interpretation, but the SCA confirmed my interpretation. I can't remember what the issues were, but because it was some time back.
Thank you, Judge. Thank you, CJ.
CJ, am I on your
Thank
list?
you, Commissioner. No, you were not, Honorable Malema. Do you want to say something?
Yes.
Could you also add me, CJ, JP Mlambo?
Please go ahead.
Who, me?
Thank you, JP. Who else? Apart from Honorable Malema and JP, who else?
I
Okay.
have just one quick follow-up question. Well, not a follow-up question, one question I overlooked when I was talking to him earlier.
All right. Okay. Okay. All right. Honorable Malema?
Oh, thank you, CJ. Judge, I was reluctant to ask you about this case because somehow I'm involved, but we'll deal with it at a high level. The issue of Manuel versus the EFF quantum, which was upheld by the Supreme Court of Appeal in part, and then the quantum was referred back to oral evidence. How did you arrive at the conclusion that it was appropriate for you to award 500,000 without any of the parties leading any oral evidence? I know that Manuel is now appealing it to the Constitutional Court, but the Supreme Court of Appeal has referred that matter back to you and said there must be oral evidence led so that whatever figure you arrive at, it is on the basis of that evidence which would have been led at that level. Thank you.
You know, Mark Twain said that nothing spoils a good story than the arrival of an eyewitness. This matter is pending before the Concord, and I don't think that the Chief Justice is interested in my musings. So my simple answer to you, Mr. Malema, is that I cannot second guess the decision that is going to be made by the Constitutional Court. The matter is now out of my hand. I've said what I had to say, and if the SCA has partially upheld me, like you said, the SCA said the matter has to go for oral evidence. We don't know what the Chief Justice is going to say. So I'm constrained to really be seen to be second guessing what the decision of the Constitutional Court is going to be. I could be wrong, I could be right, I don't know.
Fair enough. Thank you, CJ.
Thank you, Honorable Malema. JP?
Thank you, CJ. Just a short one. Judge Matojane, am I correct that in Gauteng, even before you went to the SCA, the Concord and the SCA, and when you came back, you had already started leading full court benches in the division?
Yes, it's correct.
And you have written a number of, I would call, seminal judgments that have gone up to the Constitutional Court and upheld.
Yes, I have, JP.
I see. Thank you very much for that. Just one last thing. The president asked you about case lines. I was surprised you didn't make the remark that case lines, in terms of its conceptualization, is actually more appropriate for appellate courts than for trial courts. Am I correct?
You are correct. In fact, it would save litigants a lot of money to have counsel traveling to Bloemfontein and, securing accommodation. The case line work seamlessly. Legal representative.
No, thank you, Judge Matojane.
Okay, thanks.
Thank you, CJ.
Thank you. President?
Oh, thank you, CJ. Just one quick question, Judge Matojane. I can't find your application form now. You have 2 master's degrees, don't you? One
Yes, ma'am.
from UJ and the other from UNISA. But
Yes.
what are they on? What were the focus of
The
these
first
degrees?
master's degree was, it's, what do they call it? The capita. In 1994, with the new constitutional dispensation, it was important for one to go back to school to study constitutional law. So it was coursework on constitutional law, law of evidence, I can't remember, and procedures. The second
All
master's
right.
degree with UNISA is in commercial law.
Okay, that's what I wanted. Thank you very much, President.
Thanks, President Moy.
Thank you very much. Judge Matojane, you are excused. Thank you very much. And again, we apologize for keeping you until this late.
Thanks, Chief Justice. Thanks, Commissioners.